The Supreme Court is running on nothing but Republican grievances, fringe theories, and bad vibes. Law professor and strict scrutiny host Leah Litman is here to explain. Welcome back to Defending Democracy. I'm Marc Elias. Let's get started. Leah Litman, welcome to Defending Democracy.
Thanks so much for having me.
All right, I've got so many things I want to talk to you about, but first we're going to start with your book, but I promise I got to ask you all kinds of questions about podcasting and your writings and what the hell's going on in this country. But you wrote a terrific book about the Supreme Court. And for people who don't know, Leah was actually a Supreme Court clerk, which is very rarefied air. Like the rarefied of rarefied air are the people who clerk for the justices on the Supreme Court. She clerked for Justice Kennedy, who was for many years the swing vote on the court. It's kind of hard these days to even tell people who would be the equivalent of a Justice Kennedy. And so I give that background because I'm just curious, like, what made you decide to write a book about the Supreme Court? Since my experience with former clerks is they never like to say anything bad about the U.S. Supreme Court.
Yeah, so I definitely took a path less traveled there. And so two reasons. One is, in some ways, I think this book is really coming out of my experience clerking at the Supreme Court. I was there when the court heard the big constitutional challenge to the Affordable Care Act and almost struck down that entire law based on this idea that one day the government would make you buy and maybe even eat broccoli. And so watching the justices come within one vote of almost blowing up so many people's healthcare and life-saving health insurance based on ignoring past precedent and just misassessing the risks was very eye-opening for me. And I think it really influenced how I think about the court, teach law, and whatnot. And then second is seeing people all of a sudden pay attention to the court when they overruled Roe versus Wade, but still in my mind, not really appreciate the court's long game and where these decisions were coming from and where the justices might go next.
Okay, so that's where I wanted to ask you is, people always ask me about, do I worry about the Supreme Court? And my answer usually goes something like this. Of course, I'm worried about the Supreme Court. I have to always worry about the Supreme Court. But the Supreme Court only hears between 60 and 80 cases a year, and there are hundreds of thousands of cases, probably millions of cases decided at the district court level, hundreds of thousands at least at the Court of Appeals, tens of thousands that seek cert, reviewed by the Supreme Court, and they don't take that many cases. So when I hear people like you talk about the long game, how does that play out exactly? Like, what is the long game and how does it play out where they're only hearing like a fraction of the total number of cases? You probably know the statistics, like a fraction of the number of cases that they could.
Yeah. So when I am talking about the long game, I am talking about the justice's ability to basically sit and hold tight and bide their time until the ideal case and the ideal time arrives at their doorstep, and they can decide that now is the moment they either want to change the law dramatically or begin walking down that path. And I think people underestimate the extent to which the court curates its own docket and decides whether to go fast or slow and really cultivates an image for itself, and how that can cause people, I think, to lose sight of the justice's power and their willingness to do something other than what they did yesterday, a week from now, or a year from now. And so that's kind of what I am talking about when I am talking about the long game. And how I think that relates to the small number of cases the court hears is they can influence what the lower courts are doing just by taking one case. So, for example, in the aftermath of Allen versus Milligan, that was, I think, like an important reaffirmation of the Voting Rights Act. For listeners, this was a case where the court concluded Alabama had indeed violated the Voting Rights Act by not drawing a second majority Black district. But what do you know? A few years later, the court has on its docket another Voting Rights Act case, Louisiana versus Calais, in which it could cut back significantly on what it had preserved in the Voting Rights Act in Allen versus Milligan. And I think that's kind of what I mean by the long game is they can tilt the scales, influence what the lower courts are doing, and really change what is happening in the lower courts just by taking a single case at their choosing when they think is convenient and when they think is the best time for them to make a move that they've been interested in doing for a long time.
Okay, before I ask you what their long game is, let me define who the they are. Like, is this something the justices, like, does each justice have their own long game? Or do like
Yeah.
5 justices have a long game together? Do all 9 of them? Like, sometimes I notice, like, for example, like I'll notice this with Justice Thomas. He'll seem to write something like, geez, it'd be really great if we eventually got a case that said this. Like, it's almost like he's like inviting. He's like asking
Yes.
the lower courts for a case. Like, is that just him musing, or is that like part of a, like, is there like a broader strategy?
Yeah, so I think that there is some individualization and then some coordination. So I think that Justice Thomas, Justice Alito, Justice Gorsuch, Justice Kavanaugh, and the Chief, like they all have kind of some issues in which they are particularly interested in and trying to signal they would like to hear. You know, the Chief Justice, for example, has been particularly interested in this class action issue that the court has tried to take several bites at in order to resolve. I think Justices Alito and Thomas and Gorsuch really want the court to take a Second Amendment case and to chip back on what they said in Rahimi. And so there are some individual preferences, but I think the long game is also a reference to the fact that there are certain key issues that have been so much ingrained in the modern conservative legal movement that on those issues, the justices are really on the same page and moving as a body. So in that category, I would put things like Roe versus Wade, affirmative action, Humphrey's executor, and independent agencies. And so there is a clear group preference among the Republican appointees that I think, you know, they all know where they are going to go. And sometimes that involves inviting litigants to generate a case. Honestly, I think that's partially what happened when Donald Trump went about firing a bunch of multi-member commissioners. I mean, in the New York Times was reporting how Trump's advisors thought he could do this because they anticipated having a friendly audience at the Supreme Court. And they knew that based on what the justices had been saying, doing, writing, and whatnot. So there, I think, yes, they are inviting cases, they are generating cases, and that is part of what allows them to go where they are going to go.
And my hypothesis, but you're the expert, is the following: is that um, when it comes to what I will call a strong executive, unitary executive, whatever you want, it's kind of hard to see how there are not 5 conservative votes for pretty much maybe everything other than controlling the Federal Reserve. In addition to the 3 most conservative justices, Alito, Thomas, and Gorsuch, the Chief has actually written a lot about a strong executive, as has Justice Kavanaugh. So it seems to me that Donald Trump is probably going to do better than expected in that arena, or maybe not than expected, but than people hope in that arena. And that the place where people have been pleasantly, quote unquote, surprised is really where the battle is not Donald Trump's control over the executive branch, but rather his relationship with the courts. And when it comes to his relationship with the courts, the Chief in particular is much more defending of the courts. And it seems like there is a majority of the justices to do that. I don't know where Congress fits into that, the sort of Trump versus Congress. Certainly in previous terms, the courts seem to be, in the major question doctrine case and others, curtailing the executive branch, but we'll see whether that holds. How does that strike you for an amateur theory of the court's view of separation of powers and the like?
I mean, that strikes me as plausible. Honestly, a part of me thinks that they have these theories that have been generated for them over a period of time by the conservative legal movement and the Federalist Society. They're acting those out, but also on some level making it up as they go. Like this mythical Federal Reserve Board exception, suffice to say, has not been totally hammered out. There's a law review article that gestures in this direction, but even it acknowledges you'd actually have to restructure the Federal Reserve Board in order to make it constitutional, but I guess they don't really want to do that, so they're just declaring it fine as is. So it's a combination of they kind of sort of have a theory, which is the views pushed by the conservative legal movement and Republican Party project. On the other hand, they are also willing to adapt as they go. And I think, yeah, your theory fits as good as any.
All right, so I got to ask you now a couple of questions I've been dying to ask you. The first is, which you allude to kind of in your last answer. I don't know if you know Michael Klarman, professor of constitutional law
Yes.
at Harvard. I had him on a few weeks ago, and I kind of joked with him about this, but it was in advance of knowing I was talking to you. Like, how do you teach constitutional law? Like, if in fact it is just kind of like being made up as they go along, it
Yeah.
seems like it would be quite a challenge to actually sit down. Like, at least what I offered is like
Right.
something doctrinal, plausibly doctrinal that you could tell students. How do you approach the classroom in teaching about constitutional doctrines when they're, I think I joked with Professor Klarman, I don't know how you teach federal courts. I mean, jurisdiction
Yeah.
is like no longer, I don't know what the hell, the jurisdictions of the federal courts are anymore. But how do you approach this from a professor standpoint?
Yeah. So, what I tell the students is they shouldn't look at this class as an opportunity to learn what the rules, law, and doctrine are, because that's
Hmm.
going to change, at the end of every year, certainly by the time they take the bar, certainly by the time they go to practice and whatnot. And so I view constitutional law as kind of an introduction to how constitutional change and government change works, the way our government has come to be, the way it is, understanding how law, culture, society, and politics relate to one another and the various contingencies that kind of spun out the way they did in order to lead us to where we are. So I provide them with, I try not to inundate them with too much reading material, but background material on, the political dynamics of Marbury versus Madison, or the social movements that helped generate the law on the Second Amendment, and other materials so that they can see the political context and social history in previous court decisions that is so obvious to them when they look at the modern court. And so that's kind of how I encourage them to approach constitutional law, as not a class about a set of rules, but as learning about, how our government operates and the relationship between law and politics and how change happens.
And, I have to say, you have written this book and it is a phenomenal book and I hope
Thank you.
everyone reads it. And one of the reasons why it's a phenomenal book is it is approachable by everyone. Yes, there it is. And we're going to put links to it in the notes. And seriously, I hope everyone buys it and reads it. And like I said, it's wonderful because it's so approachable. Like, you don't have to be a lawyer, you don't have to be a law professor for sure, but you don't even have to be a lawyer to enjoy it and to learn an enormous amount from it. And I say this with all due affection, but I was always under the impression that academics sort of didn't want to write books that anyone else
Yes.
would read. Like,
Yes.
I always thought that, like, from their standpoint, the fewer people who read their books, the more successful they thought their book was.
Yes.
And your writing is so engaging. It seems to run it runs afoul of what I always understood to be the law professor creed. Was that a conscious decision to write a book for everyone as opposed to something for law professors?
I'm going to take that as a compliment in describing it as not in the academic vein, because yes, that is the kind of book that I wanted to write. I approached trade presses, presses that write for a general public. That is the audience that I wanted to reach. I think that it is so important for people to understand the Supreme Court, because too often people just get these bite-sized pieces of information when the court issues a major decision in an argued case, and that is the extent of their engagement with the court. I wanted people who felt like they had an intuition that something isn't quite right about the Supreme Court to be able to get a ton of information about the court, but in a fun, accessible, digestible way that was not totally bleak, and hence all of the pop culture references and snark. But yes, I was not aspiring to write this book for other academics or primarily for people who are immersed in the law and courts. It was just for smart people who wanted to understand better the relationship between the court, politics, and society. And that was the group of people that I most wanted to reach.
So I understand why the justices, the conservative justices, might be willing to embrace fringe theories. I guess like everybody's got vibes, so like they can have bad vibes. My question to you though is the first part of the subtitle of your book, which is conservative grievance.
Yeah.
And you know, these are folks who've got a pretty good gig. I mean, everywhere they go, people stand up. They laugh at their jokes. They they work hard, but it's not exactly digging ditches at the side of the road in the middle of the winter, right? I mean, like, why is there a sort of a grievance, an attraction to a grievance mentality?
Yeah, I think it is a combination of different factors. One is I do think it is partially a rhetorical and political strategy. It is easier to whip people into a frenzy, get them out to vote, get them to do the work necessary to build a successful social and political movement if they think they are under attack. And if they
Hmm.
think they are aggrieved, and if they identify a common punching bag. So I think it is in part a strategy. I also, however, think it is a reflection of a very deep seated anxiety that as the country has become more diverse, that individuals who are white, Christian, conservative feel some anxiety about the increasingly pluralistic, diverse society that doesn't entirely look like them, that doesn't always share their views, and that is changing in their eyes. So I think it is partially a strategy, partially, right, a political strategy that leans into a very real, deep seated anxiety and feelings that some segment of the population has. I think for some people, it is both a strategy and, a set of anxiety and anxious feelings that they legitimately or sincerely have. And so I think that's probably where it comes from. But you lay it out and it's just so ridiculous. I mean, the idea that in a case about voting rights and racial discrimination in voting, they can turn the former Confederate states into the victims. Like, that should just shock and appall everyone. The idea that they can turn the mega rich into the victims when talking about campaign finance regulation as if they are so put upon and so targeted by this grossly unfair law that just prevents them from spending obscene amounts of money to drown out everyone's views. The idea that the corporate executive and the major donor is the victim. I mean, all of that is just so odd when you put it out on a page. But I do think that some people actually have those views, whether that's because they have been so ensconced in this closed universe media ecosystem that that's what they're fed, and that that's what they repeat. I don't know, but it's partially strategy, partially their feelings, and it is something to behold.
Yeah, I have to say, I graduated law school in 1993. And, you know, obviously I was always liberal and was not a part of the Federalist Society, but the Federalist Society, existed. It was actually quite, in some ways, in its ideological or intellectual heyday, in that they espoused what they said were neutral principles that
Yeah.
would be the same neutral principles no matter who were the winners or the losers. That originalism, textualism, were just neutral principles, and they would be the way they are. And I think that there are two cases that have kind of like radicalized me. The first, which I think you were referencing, which is Shelby County.
Yeah.
I actually wrote an amicus brief. You can go find it, I suppose, on the Supreme Court's website, on behalf of then Majority Leader Harry Reid. He like we were on our own on this. Nobody else joined our view, and the view that he had, which I have, is that I'm pretty sure if you ask the framers of the 13th,
Oh, yeah.
14th, and 15th Amendment what they thought of the equal dignity of the southern states, they'd say we don't give a shit about that.
Yes.
Like
Yeah.
the notion that something had to be proportionate and congruent, like the brief we wrote was basically like the Section 5 says of the 14th Amendment says that Congress has the authority to implement legislation, and that's essentially plenary authority. And the court doesn't get to make up a bunch of other doctrines to limit that authority to undo discrimination in voting under the 14th and 15th Amendments. And so that radicalized me. The more recent one, though, and then I'll let you respond to both, is the immunity decision. Now, I have represented lots of members of Congress where there is a actual provision for immunity called the speech and debate clause, which the court has like carved into 1,000 little pieces. It means this and that. There is no textual basis for presidential immunity. There is no originalist basis for
text get in the way of a good time, Marc.
What do you make of those two objections that I lodged?
No, I mean, I'm on board with both of them. So Shelby County was also radicalizing for me. It was actually the case I wrote my job talk paper about, when I was trying to become an academic, about the equal sovereignty principle in particular. So that has also been a long-running, long-festering concern/disagreement I have had that made its way into a book, intended for a general audience, even though it kind of came from a law review article. That decision is just unreal, relying on this equal sovereignty principle. And it's not just, although that's definitely very bad, that the people who drafted and ratified the Reconstruction Amendments wouldn't believe in the equal dignity or equal sovereignty of the former Confederacy. It's that in order to invent that principle, John Roberts had to insert a misleading ellipsis into a prior opinion in order to make it mean the literally exact opposite thing that it said, which is this thing of equal sovereignty was only a rule that applied when Congress was admitting states to the Union. It didn't apply to laws Congress enacted after a state was already in the Union and represented in Congress. But again, what's constitutional text or a little Supreme Court doctrine to get in the way of a good time? The immunity opinion was also shocking but not surprising. I think given that the court had slow walked it and given the extent to which the Democratic appointees, I think, pretty pointedly warned us that they were in the bag for Donald Trump, in the Trump versus Anderson case about whether states could disqualify him under the provision of the 14th Amendment that prohibited those who engaged in insurrection or rebellion from holding office. I mean, they literally wrote in their concurrence that the court was trying to insulate themselves and petitioner, i.e. Donald Trump, from future consequences. So I think the fact that they declined Jack Smith's decision request to take that up in a timely fashion, they slow walked it. Those were all indications that they were going to go big. And still the opinion they wrote is just grotesque. They twisted the court's prior cases. They inverted our constitutional scheme, which was founded on the idea that we are a government of laws, government under the law, no man is above the law. And yet they somehow made it so one special man, dear leader, right, is above the law. It's all shocking. And they seem to have no buyer's remorse about it as well, which is also deeply troubling. Like they've gone ahead and let him fire officials in violation of federal law, doubling down on this unitary executive theory that was also very present in the immunity opinion. So those should be radicalizing. And, the book, unfortunately, one, challenge in writing a book about the Supreme Court is you have to cut off the manuscript at some point. So, I had to turn in a manuscript at the end of last summer 2024. So I was able to write about the immunity opinion some, but not so much about its catastrophic effects that I think have materialized in the second Trump administration.
I'll be right back with more of my conversation with Leah Litman in a moment. But, Donald Trump and the Republicans are a menace to democracy. They want to undermine free and fair elections. They want to take away our civil rights and our civil liberties, and they want us to be too afraid to stand up and to fight back. Look, I founded Democracy Docket to cover and report on the fight for democracy in courts and to tell you what you can do to help. But right now, Democracy Docket needs your support to continue to grow its team and make sure it has the resources necessary to provide you the information and analysis you have come to expect. So become a member now to power its work forward and to gain access to exclusive content. It's just $10 a month. Please click on the link above or in the description below. I want to ask you, jumping back to your role as your day job as a professor, how you think students sort of process all this? I mean, we all know, what it was like when you were a law student. Uh, and it feels like going to law school now, from what I read, admissions are like through the roof. Like everyone apparently wants to go to law school. Maybe there's some answer in there that illuminates this, but you know, this is a generation of law students who've really only known the Trump era. Like,
Yes.
and that has to have changed what it means to be a law student and to teach law students.
Yeah.
So I'm just curious, what how you see this affecting the next generation of lawyers.
Yeah, I hesitate to make wide generalizations. I do, however, think it has to be incredibly formative and instructive to have grown up and only known a political world that has been deeply influenced by Donald Trump. I mean, I remember, really, I think the first core political memory that I have is the Supreme Court's decision in Bush versus Gore and waiting to see what happened in Florida. And I think that that has been very influential on how I have thought about government and the court. So I think that some people come to law school thinking lawyers are there to fight and we're going to lose a lot of the time, but it's still worth fighting and trying to slow things down. I think some people come and want to change things and engage in more systematic, systemic change. I think there are still some people who come to law school and think I'm not going to have to concern myself with this. And I think the initial period of the Trump administration has been disabusing them of that idea, as they have destabilized public service, as they have attacked law firms, you name it. There's just no escaping kind of our politics right now, for people who are engaged in the practice of law. So, and of course, there are some people who are excited about, what is happening and view it as an opportunity. So, you know, I don't exactly know what this generation of lawyers is going to do, when they are further into practice. But I have no doubt that, what they experienced and grew up with, is definitely going to shape their views.
And I'm curious, since you undoubtedly coach your students on careers and write letters of recommendations and clerkships and the like. One of the things that Professor Klarman said to me, which just shocked me, was that the practice, which was very common when I graduated law school, and since you clerked for Justice Kennedy, apparently was still going then, of judges and justices hiring law clerks with a little bit of heterodox.
Yes. Yeah.
Not every law clerk for a liberal justice or judge would be a liberal. Not every clerk for a conservative judge or justice would be a conservative. Law professors would be solicited for recommendations from conservative students if they're liberal, vice versa. He painted something, at least at Harvard Law School, that sounded, in his experience, a little more bleak, that it has become much more ideological. And I
Yes.
wonder if that doesn't also negatively impact the judiciary, where it's just like everything is like separated from the get-go.
Oh, like that is definitely my experience. I mean, at the Supreme Court, there's just no non-ideological hiring. And I think the ideological
So they
hiring
don't
at the
hire,
court.
didn't they use, some of them used to hire one clerk of the
Yeah, some of them
opposite?
would
Wasn't
famously
that a thing?
hire a counter clerk. It's just not a thing
Right.
anymore. It's
Okay.
absolutely not a thing. And that has also become more prevalent at the Court of Appeals. There are certainly still some Court of Appeals judges who are just not interested in ideology, or who are affirmatively looking to hire someone, with a different perspective than they have. But there are today many more who just want ideological allies, than there used to be, when I was applying for clerkships. And yeah, this is going to have horribly negative effects on the judiciary and I think the legal profession, because now people are being credentialed based on their ideological leanings and political views. And so the class of people who have been able to, or who are going to be able to have this experience of seeing the Supreme Court up close or seeing the courts of appeals from behind the scenes are going to have that, right, in many cases, just because they had the right political views. And that is not a great system when we are thinking about how to train the next generation of people who are supposed to be enforcing the rule of law.
And you also uh, spent a small amount of time at a big law firm, WilmerHale,
Hmm.
one of the firms that fought against Donald Trump. And you are now at a university, which I don't know if your particular university has been targeted by Donald Trump yet, but you have seen the administration target large institutions, the media organizations. You're a very prominent media figure yourself with with an award-winning podcast. You are obviously at one of the most elite law schools in the country, and as I mentioned, you spent at least some time in a large law firm that is an elite law firm that's actually been targeted. I'm curious. What you make of I've been very critical of big law. Like I have like
Yeah.
I've run out of adjectives to describe Brad Karp as, spineless, gutless, without dignity. I don't know how Paul Weiss partners wake up in the morning. They should be ashamed of themselves.
Same dignity as
I've
the
run out
former
of
Confederacy.
yeah, right, exactly. I have lost ways of expressing disdain for those who have capitulated to Trump. But I'm curious, like I said, you sit at a university. I'm sure
Yeah.
that's, uh, how do you process his attacks on the pillars of democracy, these large institutions?
Yeah, I mean, I think that is partially how I process them. I think in the lead up to the second Trump administration, I did a lot of reading on comparative autocracies, and how countries slid into looking superficially democratic when in reality they operated like autocracies. And that oftentimes involved effective takeovers of educational institutions, right? And destroying the independent bar or destroying the independent media. And so that is the register in which I understand the attacks on law firms, higher ed, media. They are all attacks on sites of independent sources of information and sites of independent sources of authority, possible mechanisms of checking an abusive executive branch. So that is how I perceive the attacks, which also means there is considerable urgency in resisting them. I do not have either like the luxury or the misfortune, depending on how you look at it, of being, a decision maker for a large institution. All I have is like what I choose to do kind of with my own time and profession. And I happen to think that, like, as a professor, I'm in a relative position of luxury. So, I am going to keep on keeping on. There was I think there is always going to be some concern about what they might do next. But I just think that when it comes to particularly professions that view themselves sincerely as performing an important function in society and government as upholding the rule of law, like if you think that and if you believe that, then you actually have to behave that way when the rubber hits the road and when it actually comes at some cost to you.
So I just want to press you on one small part of that. So you said you have the luxury because you're a professor, but you're at a university.
Yeah.
Do you feel pressure, like either internal or external, or like subtle, about how you do your job? Like, do you worry that Donald Trump will hear your podcast or read he'll never read your book. You don't have to worry
No.
about that.
Yeah.
Like, but do you worry? He doesn't read. But
Yeah.
do you like? How does that affect you at all?
Yeah, so I don't feel pressure from the institution to change what I'm doing or to censor myself. I do watch with some concern how MAGA and the Trump administration just sometimes identify, particular critics and just attack them on social media. During, I think, the first Trump administration, there was a group that put together a mock list of individuals they wanted to warn might be potential judicial nominees in the Biden administration. And my name was on that list, even though that was never going to happen. But it was shown on some right wing media. And I just got a barrage of absolutely horrible, messages, some of which coded as threats. And that was not fun. My podcast co host has testified before the House Judiciary Committee and Senate Judiciary Committee and was basically shamed and yelled at because of some things, very harmless things that she had said on the podcast. So, I think the reality is that, of course, the choices I am making, right, are going to close some doors, right, and they come with some risks. But those are risks that I just feel like I have to be willing to just kind of suck it up and bear. right now.
Yeah. So you referenced the thing I wanted to end with discussing with you, which is you are also a pioneer in the area of media. Democrats right now are looking for their new Joe Rogan, and I'm happy to be interviewing among the candidates for
I don't think anyone would
you.
identify me as the Democrats' Joe
You,
Rogan.
you, you, and your co-hosts started Strict Scrutiny in I think in 2019,
2019.
right?
Yep.
Yeah, and we're very early to podcasting. Now everyone wants to have a podcast. Now everyone has a podcast on YouTube. But you all recognize the power of this form of journalism, which it is, to educate, to inspire, to advance political positions, legal positions, and I'm sure you guys must sit back and sort of, both congratulate yourselves, which you deserve an enormous amount of congratulations, but also have a lot of wisdom about what the left is generally not doing right in this space, because there is a lot of discussion in the ether about the sort of collapse of legacy media and
Yep.
that, and the relative advantage that the right has generated in the podcast new media space. And I'm just curious what you make of all of that and what your secret to success is.
Yeah, our secret to success is we believe in what we're doing and we enjoy doing it. And what we believe in is messaging about the importance of people understanding the Supreme Court, and what the Supreme Court is doing. As far as, more general lessons, what the left or Democrats are or aren't doing, I mean, some of it is, I think just a failure among Democratic political officials of being unwilling to fight, unwilling to meet the moment, and generally, not being willing to take a stand and just feeling like they need to run everything through some sort of political calculus that is based on what the polls say right now, rather than recognizing their own power to shape public opinion and to move public opinion. That's just my own personal view of the Democratic Party. I think there has also been an unwillingness to recognize the moment we are in. This is true not only of how they look at the Trump administration, but also of how they look at the Supreme Court and their willingness just to mindlessly defend institutions that have fundamentally changed and are no longer institutionally equipped to protect our democracy. So those are some of the failings. I think that the search for the Democratic Joe Rogan, though, just misses some of what Joe Rogan is, which is he's not an engine for generating information or theories, in the right wing ecosystem. He just amplifies them. And so I think the search for like a Democratic Joe Rogan just misses that aspect of the misinformation or disinformation media ecosystem on the right. Now, I certainly think Democrats could improve, right, on communication. But I think that the search for the Democratic Joe Rogan is just kind of silly in some ways.
All right. Well, you still have my vote for
Thanks.
when
I think I might introduce
I want
myself
to
in the
just
future as the Democrats' Joe Rogan and see how that goes over.
that's right. Yeah. I do want to say I read a lot of books, and I read your book, and it is fabulous. I mean, it is
Thank you.
absolutely
That
fabulous.
means a ton.
And again, there is so much, I don't even know if it's fake, but there is so much reverence that in the legal profession for the Supreme Court. Like, to get people to even like do a mild criticism of the Supreme Court, I find is very hard whenever I interview lawyers and law professors, because there's, as you say, it's like this reverent institution that they feel like if they don't, sort of crowd around whatever their criticisms of, something terrible will happen. And your book really just kind of like lays out, kind of what is really going on, and that this is, as you said, and I love the fact that you teach your students this way. By the way, I'm thinking back, Walter Dellinger was my con law professor.
Oh,
Um, And we definitely learned like Marbury versus Madison was like handed down from on high. He did not give
Okay.
me whatever the
It's
political
not how I
going
teach
on to
it.
it. I didn't get that version. Your students, it sounds like, get a different version of
Yeah.
that.
Very much so.
But really, it's just a phenomenal book. And your podcast, I mean, I've been listening to your podcast. I don't listen to a lot of podcasts, but I've been listening to your podcast not since 2019, probably since 2021. I think it was actually, I'll tell you when it was. It was like right after January 6th that I got introduced to it and have been listening to it ever since. So I hope everyone listens to your podcast and subscribes to your podcast. And everyone, please go out and buy Lawless. It is a phenomenal read. It is not a hard read. I promise you, if you're not a lawyer, you'll love it. It'll be great. And Leah Litman, thank you for joining me.
Thank you so much for having me. I really appreciate it.
Thanks for tuning in to this episode of Defending Democracy. Please make sure you're subscribed to Democracy Docket's newsletters to stay informed on the latest voting rights and democracy news.